Thank you, Mr. Chairman, and welcome, Judge Temkovich. Thank you for joining us today. During your opening statement, you referenced the Bipartisan Judges Act and the veto and message associated therewith from the White House, and indicated that it was not reflective of reality and evinced a misunderstanding of the facts. I agree completely and believe that is such an important part of this hearing today. First, it's also important to note that the suggestion that that act was partisan is not rooted in facts. It was a bipartisan bill that would have not only added additional Article III judges, it would have staged the addition of those judges so that they crossed multiple administrations. So it was an unnecessary and an unwarranted veto that has exacerbated the burden on the courts and continued to inhibit access to justice. I come from the Middle District of Florida, where, as I'm sure you know, is one of the most populous and the busiest districts anywhere in the United States of America. Whether we go by weighted caseloads or unweighted, it is an incredibly busy district. I had the privilege early in my career of serving as a judicial law clerk to one of our Article III judges. Later, as an AFPD and an AUSA, I spent much of my career inside the walls of the Tampa Federal Courthouse and can attest firsthand as to just how diligent and hardworking those judges, the magistrates, and everyone else in that courthouse is, and how vital it is that we properly fund our courts as a co-equal, independent branch of government that needs to be properly staffed and funded to do its job. You mentioned something else in your opening that I want to go back to, and that is the concept of speedy trial. For those who are not criminal practitioners, would you please elaborate for us, Your Honor, on the distinction between civil and criminal cases? What happens if criminal defendants do invoke their right to a speedy trial? What then happens to a judge's civil docket, and how does that affect access to courts?
Well, as you know, as a former law clerk, the criminal cases take precedent over the civil cases. A defendant in our system of justice is entitled to statutory protections that ensure that the trial occurs on a speedy basis. The Constitution also has a due process guarantee that requires judges to expedite those cases within timelines that are set either by statute or by case law. So if we have an inadequate number of judges in district courts with particularly heavy criminal dockets, presumably the Middle District of Florida, which I see it would be eligible for several new judgeships, it can put a lot of pressure on the rest of the civil docket if those criminal cases are taking over the time that's necessary to try them.
That's exactly, I think, something that's very important to understand. So when that happens, then civil litigants, individuals and businesses that have disputes that need resolution in the courts, their cases will get delayed. Another thing that you touched on is the concept that when that happens, when those delays are too pronounced, when they're too long, that can have a chilling effect on people coming to court or electing to use a trial as a potential resolution for their dispute. Would you share with us a little bit more about your view on why it's important that Americans who have a dispute, that want it resolved, that would like to go to trial, have the ability to utilize our courts efficiently and effectively to do that?
Yeah, every dispute in this country should be resolved quickly, fairly, and efficiently. And the current status of the federal courts, because of our judgeship needs, is compromising the ability of those types of cases and those types of litigants to have their day in court. And without getting their day in court, we think that erodes trust in the judiciary, faith in our system. And to the extent we have an adequate number of judges to maintain and move our dockets, everybody benefits from that.
Unless I noted in your introduction today that you take on a number of special responsibilities within the Judicial Conference, and I know many of your colleagues also do this. So we're here today, we're talking with one of the easiest to access data points, which is the overwhelming number of cases that are assigned to every judge across America. Tell me why those extra responsibilities, judges who are willing to teach, to take on the FISA court, to work on cybersecurity, why are those important, and how does that add to the workload of a judge who's really performing their job very well?
It's an important question, and it's also equally important to note that the survey results, the methodology that we use to estimate the number of judgeships that are needed is not based on those extra duties. So the numbers that you get for the basis for this legislation are purely based on what the court is doing deciding cases. And most of our judges do extracurricular activities, teaching, going out into the community, serving on judicial conference committees like I am. And those are all important functions for the judges, and I think it's important for the public at large. But we don't get credit for those for purposes of this judgeship bill. So just note that that's in addition to what the basis for this request is.
Thank you, Mr. Chairman. I'm out of time.